employers is to have essentially a mental checklist running through in your own mind. Okay, this person is asking for something. For example, asking for time away from work. And what are the laws that apply to my business and apply to this employee? And if your business has fewer than 500 employees, and your employee, then any employee would be eligible for emergency paid sick under the Families First Coronavirus Response Act. So you're not even really dealing with an accommodation request at that point. If someone is asking for time away for work for one of the reasons that would qualify for FFCRA leave. And just as a reminder, those reasons, like to zoom out for a minute, we're kind of assuming some knowledge here, but I want to be careful because, we don't know everybody who's listening in.
Right.
The Families First Coronavirus Response Act, the FFCRA, went into effect April 1. And what it does in essence is it provides two different types of leave. There's a 2-week leave called emergency paid sick leave. And that applies to really any employee of a business with fewer than 500 employees who is seeking leave for one of the qualifying reasons. And then there's another bucket, if you will, or another type of leave called the expanded FMLA leave, which is specific to leave needed to care for children when school or child care provider or place of care is closed because of COVID-19 reasons. So that's what the FFCRA does. And now what are some of the reasons in addition to child care that somebody could tap into that FFCRA emergency paid sick leave? That would include if the individual, him or herself, the employee, is subject to a federal, state, or local government quarantine order, which, keeping in mind now, many of our New England states have post-travel quarantine orders that are now government orders. So if someone travels outside of certain states and then returns, they are under this order that can trigger FFCRA leave. Another time you can qualify for FFCRA emergency paid sick leave is if a healthcare provider has advised you to quarantine. And that might be either because the healthcare provider believes you have COVID-19 or you've been diagnosed with COVID-19, or it could be because you have an underlying medical condition that makes you more susceptible to COVID-19. You can also take emergency paid sick leave under the FFCRA if you're experiencing symptoms of COVID-19 and you're seeking a medical diagnosis, or if you're caring for someone who is under an order or under medical advice to quarantine, or to care for your son or daughter whose school or place of care is closed. So when an employee is coming to you for one of those reasons, we're not really dealing with an accommodation request in the traditional sense. It doesn't require an involved analysis. You're just looking at, hey, am I dealing with an employee who needs leave for one of these reasons? And if they do, the answer is going to be yes, unless certain very rare exceptions apply. But otherwise, the answer will be yes.
So, and I know travel has come up so often as well that with the travel bans and so forth, with people, if our employees leave the state and go to, say, a hotspot like Florida or something like that, do we have to still cover them under FFCRA and pay them to quarantine when they return?
Yes, yeah, you do. There are certain very narrow exceptions for essential employees of essential businesses where there can be some workarounds. It's also state dependent as well. For example, here in New Hampshire, where I work, our governor has said that if you travel outside of certain New England states, then you must quarantine for 2 weeks. And there's no workaround for that by getting a negative COVID test. Other states allow a workaround with a negative COVID test. But for New Hampshire employers, for example, that means if you grant an employee, say, 1 week off to go visit family in Florida or to hit the beach in Florida, whatever it is they want to do, it really turns into a 3-week time away from work, which is very difficult. We understand the reasons for it and the public policy reasons for it, but from a business continuity perspective, very difficult for employers to manage. And in that instance, just to go with that example of a week-long trip to Florida and then having a 2-week quarantine period, the result would be that the 1 week of time in Florida would be paid presumably through your regular vacation benefit, but then the 2 weeks could be paid under the FFCRA unless the emergency paid sick, unless the person's already exhausted that time.
Right, right, exactly. And we've had a question come in about that, which is how often can an employee use the 2 weeks FFCRA coverage?
That
How,
is a great question. You're one and done. It's, bluntly, it's one and done. A person gets, well, I should be a little more clear. A person gets up to 2 weeks of this emergency paid sick. So I say one and done in the sense that if you used it for a 2-week quarantine, you'd be done. You would have exhausted your 2 weeks. If instead you use it in smaller bits, smaller pieces, then you could still have more time left, but a person only gets 2 weeks.
wow,
If a person works full-time, for example, which under the FFCRA is defined as working 40 hours a week,
right.
they get 80 hours of FFCRA time. And that's it,
Okay.
not more than the 80 hours for the emergency paid sick reasons. There's another, as we mentioned, whole bucket of time for childcare. But it's not 2 weeks per incidence or 2 weeks per travel or 2 weeks per possible infection. It's 2 weeks period, and then you're done. Remember too, Rhoda, that this law is set to expire on December 31 of this year.
Right.
So we've had it in place since April 1, and we've only got about 3 months left to go.
Mm-hmm. Absolutely. Another question is coming related to that, which is, so if an employee has a negative test, they still cannot come back to work. How does that not negate the unknown 2-week quarantine? You mean to say that again? If an employee has a negative test, they still cannot come back to work because you said they have to, it's regardless of whether they have a negative test or not. How does that not negate the unknown 2-week quarantine?
I'm not totally sure I'm following the question.
Yeah, me either.
But what I will say is this. Number one, it's state dependent. So different states have different safer at home or stay at home orders in place.
Right.
What I was referencing earlier pertains to New Hampshire. Our New Hampshire universal guidelines say that if you travel outside of the New England states, then you must quarantine for 2 weeks. And it makes no difference whether you get a negative test or not. In other words, there's no workaround. You
Right.
quarantine for 2 weeks.
Mm-hmm.
The rationale behind that, as I understand it, is that a negative test, it's an imperfect thing. The tests are not completely accurate, first of all. And second of all, if somebody tests early, it's possible that the virus is in their body but hasn't incubated long enough in order to show up on a test. In other words, if I traveled to Florida and got back today and took a test today, but I was exposed yesterday, my positive test might not show up, until 5 or 6 days have passed.
Right.
And so the concern that's been articulated in some states like New Hampshire is, hey, we don't want for there to be a workaround with an early negative test because we're still very concerned with transmission of the virus.
Right.
Other states have made different determinations, and I'm not judging. I'm not judging. I don't envy the governors of any of these states, and I am not judging the decisions that they've made.
Right.
I just want all of your listeners to be clear that, if you're in New Hampshire, you have one set of rules. If you're in Maine, you have a different set. If you're in Massachusetts, you have a different set still. So you want to be aware of your state-specific requirements.
Exactly, for sure. And so we've had a question here. What kind of paperwork needs to be completed by the employee or by the employer for FFCRA?
That's a great question. The IRS has a really helpful FAQ, frequently asked questions, on exactly this issue. And one of the things, Rhoda, you and I talked about ahead of time was sending out to participants afterwards links to things. So this can be one of the links that we send, but the short answer to the question, understanding that we'll send the link to follow, is that in order to take just the 2-week FFCRA emergency paid sick, we're not actually requiring lots of documentation. The reason for that is the federal government is recognizing that it can be difficult to get documentation from healthcare providers right now, but what we would really need is if it was a quarantine circumstance because of travel, we'd want some documentation that the person traveled. And then you would want to make a record as the employer of the state requirements that you're in. So for example, if you're in New Hampshire, you'd make a note that our universal guidelines that were updated as of August 27, require quarantine post-travel so that this person is under a state government order.
Right.
And for, just to finish that thought too, other people might be wondering, well, what if someone is taking FFCRA leave to care for a child? Or someone's taking, you know, just to stay with that one for a minute, if they're taking emergency paid sick or expanded FMLA under the FFCRA to care for a child, you would look for documentation such as, what is the child's name? What is the name of the child's school or daycare provider or, you know, other place of care? What are the dates leave is needed? And you would also look for a statement from the employee that no other suitable adult is available to provide care during that period. For example, if a child has both a mom and a dad who live at home, both parents cannot simultaneously take FFCRA leave because presumably one parent could care for the child. Presumably both parents are not needed to be there at the same time.
Right.
There's also different, you know, requirements that you would take. You can take FFCRA leave to care for a child who's under the age of 18 or over the age of 18 with a disability that renders the adult child incapable of self-care. So you'd want to have some statement from the employee that says, this is my child's age. And if they're over the age of 14, but younger than 18, you can also require a statement about the special circumstances that require you to be there. You know, one example might be that I've seen from one of my clients is someone has a 17-year-old child who has a learning disability or ADD or ADHD or something of the sort that makes it very difficult for the child to concentrate on schoolwork. So the parent needs to be there to keep the child on track with the schoolwork. And so the parent is providing that care. And that would be the statement that the parent would provide. Notice, I did not say that we would require medical documentation of the child's diagnosis.
Mm-hmm.
So we would just, you know, we would just require a statement to that effect.
So should we get that statement in writing from the employee in order to keep sort of a tracking, like a tracking list of, you know, knowing who is out and what their reasons are, that kind of thing?
I think that's best. I also know from experience, as you might as well, Rhoda, that not every employee complies with these requests. And there's some utility in having people use up this FFCRA benefit. So what I've said to some employers is the FFCRA rules allow you to accept the statement orally or in writing. And what I've said to some employers is, you know what, if the employee's not getting something to you in writing that you've asked for, take that bull by the horns and write to the employee so that you've documented it. You know, an email, for example, to the person that says, dear Rhoda, great talking with you the other day. When we spoke, you told me A, B, C, D, E, you know, and that way you've documented it. You can print that out and put it in your file or keep it electronically. I've just revealed my old-fashioned sense of hard copy documents.
That's whatever works for you, though, is what I'm hearing you say, right?
Yes.
So here's another question. If the employee doesn't inform the employer that they're traveling and they find out later, do they have them serve the remaining time under quarantine? Is there discipline that they can impose for not disclosing they've traveled against the ban put on them by the employer?
Yeah, that's a really interesting question. And yeah, I mean, it might be a travel ban by the employer, but also remember some states have these. It's not a ban. It's not saying you can't go, but it's saying when you return, you have to quarantine. So if you learn about it after the fact, I think it probably is best to have the person serve the remaining time of the quarantine period. You might think, boy, the cat's already out of the bag, but remember the whole purpose of all of this is to minimize exposure. So if someone came back to work for one day, but you have them serve the balance of those 2 weeks in quarantine, I think you've still done a good thing from the point of view of minimizing exposure.
Right.
Yeah.
That makes sense. That does make sense, because I think, the question had come up is, can employers tell their employees, you can't leave the state for a person?
Yeah.
Can they do that?
Probably, depending on the state you're in. So that's another lawyer answer, probably.
Okay.
There are some states in our country that have laws that say that you cannot discipline or terminate people for engaging in lawful activities outside of work. And so if you are in one of those states, you can't really regulate people's lawful activities outside of work. So it's perfectly legal to go to Florida. So you can't say to somebody, hey, if you go to Florida, I'm going to fire you, or that type of thing. So you can't really restrict it. But in New Hampshire, for example, you could say to somebody, no, I'm not going to approve your request to go here. What I've been saying, though, to employers is, look, we don't want people to have an incentive to lie. We want to know if someone is traveling outside of New England, because we want to minimize exposure in the workplace to the potential virus. So I don't want to have any incentive for people to say, oh, I'm not doing anything, or that type of thing. We want people to be forthcoming. So I'm not a fan of a full ban of saying you can't do this. Instead, I've landed in a place personally where I think it's a good idea to discourage travel, to say, hey, employees, let's educate you about our state's safer at home guidelines or stay at home guidelines. Here's what they are. Here's, what's going to happen. And we strongly discourage travel outside of New England, for example, without flat out prohibiting it, is what I think is best. I think otherwise you're incentivizing people potentially to be dishonest about their plans.
And I love that phrase. We don't want to incentivize people to lie. I like that. When you think about it that way, that works. Absolutely works. Let's see, we have another question here. Is this like unemployment and the employee can apply after they've left the company? I believe that's asking about FFCRA and the 80 hours.
Okay, that's a great question. Short answer is no. The FFCRA is a benefit that the employers pay. So employees will see it in their paycheck. The employer pays the benefit.
Right.
And then the employer can receive a tax credit for that. Depending on the reason why a person is taking FFCRA, they can either receive 100% of their pay or 2/3 of their pay, up to certain caps. If you're taking FFCRA leave for yourself because you have to quarantine or you are sick, then you can have 100% of your pay up to certain caps. If you are taking FFCRA leave to care for somebody else, to care for your child or care for somebody who is ill, if it's about somebody else, then it's 2/3 pay. But that pay is paid by the employer, and then the employer recoups the cost through tax credits. Right. So it's not like unemployment, which is administered by the state. This is administered by employers.
Right, so the employer is initially out the money, but they can apply for a tax credit.
Exactly, exactly. Okay. The idea is that it's cost neutral.
The idea. Hopefully that will be the case. We've had a question here also for parents with children at home because of school closures. 12 weeks go by pretty fast. At the end of that 12-week leave, do we still need to hold their job?
Yeah, this is like the $1 million question, right? Because we're beyond 12 weeks since April 1, and a lot of people have been struggling with these issues. The short answer to the question, do you still need to hold the job, is probably not if they need the continued leave, because the legal requirement is to provide the 12 weeks of leave. Once that's exhausted, you're not legally required to provide more. It's done. The reason why I'm speaking hesitantly is because when I've talked with employers about this issue, there's always the practical overlay, right? And that is to say that, do you really want to lose good and valuable employees? Particularly if you might be able to work with them, if there might be a solution, or if something is short term. And also thinking about how long it takes to recruit a new person, train that new person, and get that new person up and running. So I personally have not seen many employers looking to end the employment of people when they run out of those 12 weeks. But that's not to say that we won't see it in the next few months. And the short answer is the FFCRA provides somebody with those 12 weeks. And once those 12 weeks are used up, they're done. Mm-hmm. And if the person's not able to come back to work, there's no obligation to provide more time. You'd want to be sure of several things, Rhoda. Number one, you'd want to be sure that the person knew that they were using the FFCRA expanded family leave to care for the child, and that the clock was ticking on those 12 weeks. You'd want to make sure that they knew that you didn't just pull the rug out from under them, that they knew that they were approaching the end of their 12 weeks and had an opportunity to try to make arrangements to be able to come back, and that they understood the consequences of not coming back. I'm not a fan of surprising people. I don't think that plays well. And we're in a situation now, nationally and globally, where the expectation really is flexibility, as well as some grace towards people, frankly.
Yeah.
And so you would really want an employee to understand where he or she stands and what the consequences are, and give them a true opportunity to try to get back to work and preserve that employment. But if at the end of all that, it doesn't work, then the employer's exhausted their obligations. They've extinguished it.
Well, it seems to me that the whole consistency tenet would come into play as well. If you're going to make a decision like that for one person, you got to be careful about not making it for another, right?
That's absolutely right. If your rock star employee needs more time, and you say, you betcha, anything to keep you,
Right.
and you know, an employee who's less than amazing needs the same, and you're like, you know, to heck with you.
Right.
Remember our same laws too around discrimination, that, you know, we can't, for example, allow women extra time because we have empathy for what it's like to be a working mom, and not permit men the same time, you know, or, you know, making distinctions based on age, race, color, national origin, all of our regular protected, all of our regular protected activities, because our discrimination requirements haven't changed. We cannot discriminate.
Right. Right. There's a lot to consider, isn't there?
Yeah.
We have another question here is, do you know if the Department of Labor has released forms that can be used to document the FFCRA leaves? This person heard that there was going to be, we do know that new FMLA forms were released in July, right?
Yes. Yes. If you all don't have the new FMLA forms, you want to make sure that you have those new forms. That's something else that we can send out to you after this presentation. And I'm not aware, we can double check. I'm not aware that there are any special FFCRA forms to use. You can make, you know, you can make up some simple forms of your own. And I think that's honestly because the requirements are so slim. You know, the Department of Labor is really expecting employers to pretty much say yes to these FFCRA requests, so long as they're checking the boxes of the FFCRA reasons.
Okay. All right. That makes sense. And then we have a question about New Hampshire here, is that this listener believes in New Hampshire, the Attorney General stated that COVID could not be covered under workers' comp. Do you know if that's true?
I do, but let me explain that a little bit more. And before I launch into my explanation, I saw pop up here, a listener wrote that SHRM, Society for Human Resource Management, has sample FFCRA forms, and I'm glad for that. SHRM is a terrific resource.
Yep.
So I'm glad for that. So what the New Hampshire Attorney General said, and different states have taken different stances on this, is the question is, if someone becomes ill because of workplace exposure to COVID-19, can they file a workers' compensation claim? And our New Hampshire Attorney General said, probably not. And the reason for that is because it would be very difficult for somebody to prove that it was in fact the workplace that caused that exposure. Could have been the grocery store, could have been something, I'm not picking on grocery stores, but you know, there are so many places where it can occur. So the Attorney General did not say, no, it's never going to be covered under workers' compensation, but essentially said it would be difficult for somebody to demonstrate that in fact, the COVID-19 virus arose out of that workplace exposure. Something that is helpful for people to know, and is also mentioned in that same memo by our New Hampshire Attorney General, and the same is true in many other states, is that the workers' compensation laws are designed to be an employee's exclusive remedy for workplace injuries and illnesses. And what I mean by that is, you know, if somebody claims that they broke their knee at work, They file for workers' compensation. Whether the workers' compensation claim is accepted or rejected by the employer's carrier, the employee can't sue the employer about the broken knee. Their whole remedy is around the workers' compensation system.
Mm.
The same is true for COVID-19, that even if the claim is rejected by the workers' compensation carrier because they could not prove that the workplace was the cause of the COVID-19 virus the person caught, the person then doesn't have a lawsuit to say, well, you didn't adequately protect me from this.
Oh, interesting. That's good to know. That really is good.
Yes. Yes. I do think we'll see lawsuits for other reasons,
Oh, yes.
but not that one.
Most likely we will. So we have another question here. It says, what about an outpatient healthcare provider and workers' comp? I'm not sure I understand that question. Does that make sense to you? What about an outpatient healthcare provider and workers' comp?
If a person
Oh, if the
is,
person works for an outpatient healthcare provider and workers' comp, maybe that's what they're asking.
yeah, if that's so, then certainly that would be a detail. It might be more likely that somebody working in a healthcare center
Yeah,
could establish that their exposure to the virus was caused by work because maybe they are someone who is administering COVID-19 tests, or they're otherwise in close proximity with COVID-19 patients. But again, it's not, to be clear, it's not that COVID-19 is never going to be covered under workers' compensation. It's just that it's going to be difficult for people to prove. And other states are different. For example, I know there's probably not anybody listening in from California, but the California governor, just by way of example, came out with the opposite and said, we are going to try to interpret workers' compensation coverage to cover people. So it's a state-specific analysis.
yeah. I would imagine, people that work in the healthcare environment, they have a better case in terms of they're handling, COVID patients. So it's likely that there was some exposure there, or even in a workplace, a non-healthcare workplace, if you have a cluster breakout of 3 or 4 people that work in the same department, then you probably have a better case then at that point too, I would imagine, right?
Yeah, I think you're nailing it, Rhoda. It's really a fact-specific inquiry. It's asking a bunch of questions and looking at the facts in that particular circumstance to determine whether it's reasonable to believe that the virus arose out of and in the course of that person's employment in the workplace or not.
Right, okay. And what if we have another question here, which is, what if OSHA assigns the responsibility of employees catching COVID to the workplace? Would that enable a lawsuit to find the employer responsible?
So there are, of course, under OSHA, there's a general duty to provide a safe workplace. And if OSHA came in and did an investigation and found that the employer violated their duty to provide a safe workplace, could somebody bring a claim under OSHA for that, with the Department of Labor for that? Yes, somebody could bring a claim under that. For sure. It could also, one of the other things, and I'm going a little bit sideways on you here, but workers' compensation, of course, only applies to an illness or injury of the employee. But let's suppose we had a circumstance, Rhoda, where an employee who works in a setting where there's an outbreak, or they've had some exposure to the virus, the employee gets the virus, but then transmits it to family members as well, or other people with whom they reside, right? In my mind, the question too there is, let's suppose somebody transmits it to their spouse. Well, the spouse is not going to be barred by the workers' compensation system from bringing a lawsuit. The spouse could, in theory, sue the employer to say, you were not careful, you were negligent, and what got me on this tangent was if there was a finding by OSHA that the employer had violated their duty to provide a safe workplace, that spouse presumably could use that as evidence in his or her lawsuit to say, you did not provide this safe workplace, and I've got some proof that a government agency charged with enforcing this found that you did not.
Right.
So that's a different way that lawsuits might come up.
Mm-hmm.
And not be barred by the workers' compensation system. So to zoom out, without getting into the particulars about all the different ways lawsuits can come up, I really do want to urge employers to be thinking so carefully about minimizing exposure. I know it's really hard to have lots of employees out, and administering these various types of leaves of absence and accommodation requests can be tricky. But truly, if there's some suggestion or reason to believe somebody might have been exposed and could be a risk, you want them out of the workplace.
For
From
sure.
a business, yeah, from a business continuity perspective as well, you don't want to have to shut down your whole place. You know, you'd rather have one person out and not affecting others than having to close your entire workplace. So I just like to periodically zoom out and think about what's the purpose behind all of this and how can we best help the largest number of people. Does that make
Yeah,
sense?
those are very good points. We had another question come in. Says we have an employee out on FMLA for the birth of a child. So after she takes 12 weeks FMLA related to the birth of a child, can she then request another 12 weeks under FFCRA?
That's a great question. And the answer is no. You get your 12 FMLA weeks are all you get. So if you use them for a COVID-19 reason to care for your child, then they're done. Or if you use them for the birth of your child or the adoption of a child, you've used up your 12 weeks. The person would, however, still have the 2 weeks of paid emergency sick leave, but that's it, just those 2 more weeks.
Okay. So they can run concurrent is what you're saying. You know, they don't like come one after the other.
Um,
Traditional FMLA and the EFMLA can run concurrent basically.
Yeah, I guess the way I think about that, that might be one way to think about it. A different way I think about it is the FFCRA did not give anybody any new FMLA time. You
Okay.
still only get 12 weeks.
Okay.
What the FFCRA did was give a new reason to take FMLA,
Ah,
but it didn't give any more weeks. You still get the same 12 weeks you always got. The other thing it did, just to be clear for everybody listening in, is, you know, the FMLA that we've all known and loved since 1993 applies to workplaces that have 50 or more employees, and applies to employees who've worked at the place of business for at least 12 months and they've performed at least 1,250 hours of work, etc. What the FFCRA did as well is said for this one new reason, just for this one new reason of caring for children because their school or daycare or place of care is closed, we are going to expand it so that it applies to all businesses with fewer than 500 employees. There are some rare exceptions for smaller businesses. And we're going to let it apply to anyone who's worked for you for at least 30 days. So they changed the eligibility requirements just for this one reason for FMLA, just the caring for a child because school or daycare or childcare provider is closed. It did not change the eligibility criteria for our normal FMLA reasons like the birth of a child or to care for someone who is ill and that type of thing.
oh, that's a very good distinction. Thanks for pointing that out. That
Yeah.
you really do have to look at both there. That's terrific. So we've had another question here to clarify. Oh, wait, you already clarified that. How about the FFCRA applies to public employers too? Public, like governments, or does not?
I'm struggling with that. Let me double check and get back. I don't personally represent any cities or towns or school districts. So it is not something I focus on. I believe that it does. I'm embarrassed. I don't know the answer off the top of my head, but I don't want to guess and misspeak.
Okay, yeah, no, we'll make a note on that then. Then there's another question that says, what's the responsibility of the employer to accommodate an employee that is immune compromised and may not want to work in the office? Are we required to accommodate under ADA?
That's a great question. And what that question does is beautifully bring together the intersection of the FFCRA and the ADA. And so under the FFCRA, someone who's immune compromised might be recommended by their healthcare provider to work from home or to quarantine or be home or that type of thing. If the person cannot work remotely, some of this also ties into remote work, but if the person cannot work remotely and their healthcare provider recommends that they not be at work because they're immune compromised, then we would be looking at the 2-week paid FFCRA. And then for any additional time for that person who cannot telework but is immune compromised, we would be looking to the regular FMLA if that person is eligible for the regular FMLA and the business is covered by it. And if the certification of healthcare provider form showed that the person needed the time, or we'd be looking at an ADA reasonable accommodation to provide a leave for someone because they're immune compromised.
Mm-hmm.
On the other hand, if the person can telework, if they are in a job that can be done remotely, then FFCRA doesn't really kick in, because FFCRA is for when the person can't work and needs the money. If they're able to work, then they're going to earn their regular wages or salary, so they don't need to use the FFCRA. And you're just going through that regular ADA analysis, if you will, of does the person have a disability? Remembering that proving a disability under the ADA is a pretty low bar, and most conditions that would cause someone to be immune compromised would probably qualify. It's a sweeping statement. You'd want to look at it case by case, but would probably qualify. And then the question is it reasonable to allow the person to work remotely? Are they in a job that can really be done well remotely? Are there any special considerations? Is the person working on something that is super secret and confidential, and it would be terribly detrimental to your business to have that confidential information off-site, for example? Or is it a job, like mine as a lawyer? Of course, I deal with lots of confidential information, but we've got, very secure resources for keeping all of our clients' confidential information safe. And my job could be done remotely, and has been a lot these last many months.
Thank goodness.
Yeah.
Thank goodness for that. Okay, so we have another question here. What is, if the employee is furloughed and then gives birth during a furlough, does any time after maternity count towards regular FMLA? Well, if they give birth while on furlough.
Yeah, that's a great question. So if an employee is furloughed, that means the employer has made work not available. The employer has said, I don't have work for you. And when the employer does not have work for someone, we cannot count that time against the employee's FFCRA or FMLA. FFCRA and FMLA can only be utilized when the employer has work for somebody and wants them to be working, but the employee says, I can't because I'm in labor, or I can't because I have this newborn, or whatever it is. And so if somebody is furloughed, then that's a status unto itself. They're just furloughed. And so when the person is called back to work, they would still have all of their FMLA time available to them, their FFCRA time, and so forth.
Well, so let's say that you call the person back and they say, oh, I've just had a baby, so now I want to apply. Can the employer then say, oh, no, not going to, go back on furlough? We're not going to bring you back then? Or is the cat out of the bag at that point? What do they do?
Yeah, that's a great question. And I know a lot of employers, particularly when the beginning of the pandemic was just fast and furious, and then we were trying to recall people as quickly as we could and everything, a lot of employers were just like, just stay on furlough,
Right.
And it just felt easier. That's not the correct answer, though.
Mm-hmm.
The correct answer is we cannot discriminate against people, because they are pregnant, or because they've had children, or because they might need FMLA or FFCRA leave. We can't discriminate against them or interfere with their rights. You would instead recall them just as you would anybody else, but recall them to leave. You would, instead of coming back to work and working, they would be recalled and immediately go on whatever leave applies, whether it's the FFCRA emergency paid sick or FMLA or whatever it is.
Mm-hmm. Oh yeah, that makes sense. That really does. Let's see. We have a question here that says, what can happen if an employer fails to approve an intermittent FMLA request in a timely manner, assuming the employee has met all applicable deadlines for the claim submittal? And can an employer manage COVID-related FMLA requests differently than any other FMLA leave?
Okay.
Request?
So there's a lot bundled up there.
There is.
Help me if I don't answer everything, prompt me on some things. So, you are obligated to promptly respond to employees. And if there's some delay, some reason for the delay, and I'm trying to think of what that, would be. If there's a need to find coverage or some short delay, maybe that's not a huge problem. But if somebody needs leave, they need leave. They can't work.
Right.
And one of the things that I always think about is the clock on leave, if you will, doesn't start ticking until you tell somebody they're on the leave. And so it's in the employer's interest to get that going as quickly as possible, bluntly, right? Because if someone's going to be out for a big chunk of time, you just as soon get the clock ticking so that you can capture those weeks and not have it run longer than it need be. So there's that, there is a need to get it going promptly. I think part of the question too was what can happen. What I would imagine is if the employee really needs leave, they're going to go.
They're going to go,
They're,
right.
you know, and then the employer's not going to be able to discipline them or hold them accountable if they're taking leave that's legally protected under these federal rights.
Right, right. That's a good question. In terms of the intermittent, I know we've had some questions also about children's school schedule, that they're going to school on Monday, they're home on Tuesday, they're going to school on Wednesday. So do each of those consist of different separate events, or are they together? How does that get worked?
It's a great question. And, as if people might know from following the Department of Labor alerts and updates and that type of thing, the U.S. Department of Labor recently issued updated FFCRA regulations. And in those updates, they clarified this bit about intermittent leave to care for children when school is closed or daycare is closed and that type of thing. And two things are true and they're confusing. So I'm going to say them both and then we'll walk through examples. Number one, it is true that in order to take intermittent leave to care for a child, you need the employer's permission.
Right.
In theory, the employer can say no. The other thing that's true is that the Department of Labor has said in the exact scenario you posed, like say it's a hybrid model and the child is going to school Monday, Wednesday, Friday, but not Tuesday, Thursday. The Department of Labor has said each day of closure is a new event. So it's not actually intermittent leave, even though it looks like intermittent leave. It's a new leave sort of starting each time.
Ah.
And the reason I say it gets confusing is, and I say this sort of affectionately as a lawyer, it's written like only lawyers could write it. Like, what do you mean? It looks like an intermittent leave and it looks like you're sort of threading this strange needle.
Right.
But the short of it is that if you have a parent whose child either cannot go to school at all because the school is entirely closed and remote, they're going to be able to take, assuming your business is covered by the FFCRA, they're going to be able to take up to the 12 weeks of time to care for their children in that remote phase. And similarly, if the child goes to school 2 or 3 days a week, but not the other days, those other days are not going to be considered intermittent leave. What is, however, intermittent leave, and this can get a little bit more confusing, is if you need little pockets of time during the day, not the whole day. So that gets confusing.
Yeah.
My honest advice to employers, what I've been saying around this is work with people, figure out what the circumstance is, figure it out, and recognize, frankly, that we're all muddling through this together, including the schools. The schools have worked very hard to put together these elaborate plans. The plans don't always stick. So
Yes.
Things change.
Yes, that's a very good point you make. There's no question about it. So we've had another question come in that says, if an employee is required to quarantine or needs to miss work for a COVID absence and the employer is not covered under FFCRA, can the employer not pay the employee for the missed time or require them to use PTO?
So that's going to depend on a couple of different things, but possibly you would not have to pay them. Possibly you could require them to use PTO. What it's going to depend upon is whether the person is salaried or hourly, and depend on your state laws around payment, because different states have different requirements around this. But in general, with a caveat, you got to check your state law, but in general, if you're dealing with an hourly employee and you're not covered by the FFCRA, and the person is not able to come to work because of some COVID related absence, there would be nothing that would require you to pay that individual. You might, if your policy on your sick benefit or your PTO benefit is written in a way that you can just automatically apply that time, you could do that, require the use of it, automatically apply it, or it could be permissive, meaning the person might ask, may I use this?
Mhm.
And you would grant it or deny it under your ordinary processes. But you want to think about, you know, hourly versus salary. If the person is salaried in New Hampshire, we have to think about, have they worked any portion of the pay period?
Mhm.
You know, other states might be more around the pay week, you know, and thinking about that type of thing. But possibly you would not have to pay the person.
Okay. Okay. Interesting. But there again, you want to be consistent, right?
Yeah, you would want to be consistent in your approach, consistent in terms of treating people who are similar, treating them similarly.
Right.
So you might treat your salaried and hourly folks different because you have different rules that apply to salary and hourly,
Mhm.
but you'd want to treat all your hourly folks the same, for example.
Okay.
If you're a multi-state employer, you might treat people in one state different than the other because you might be following different state requirements, but you treat everybody, you know, in the state of Maine, for example, the same if they're all hourly, and everybody in New Hampshire the same if they're all hourly.
Right. Right. That makes sense. Okay. Excellent. We've also had some questions around that were submitted in advance around what if I have my elderly parent living with me in my home and they need care, they can't care for themselves? Is any of my need to be home for them covered under anything related to FFCRA, or do I have to use some other thing to try and stay home to take care of them? And I'm also worried about maybe infecting them if I go into the workplace.
Yeah, yeah. So depending on the reason the parent needs care, possibly the 2-week emergency paid sick under the FMLA could cover. And that would be that if the parent was experiencing COVID-19 symptoms and seeking a diagnosis, if they were recommended by a healthcare provider to quarantine, and that type of thing, you could tap into the 2-week FFCRA. But if that's not the case, then we still need to think about our regular FMLA rules. So if you are an employer that's covered by the regular FMLA, again, you got 50 or more employees, and if the person is eligible under the FMLA leave to care for a parent with a serious health condition is our regular ordinary FMLA that we can't forget about now, whether that's related to COVID-19 or not. But again, there has to be some need to care for the person. So if you have a fully functional parent living with you and they can do everything by themselves, but they happen to be immune compromised, I don't know that a healthcare provider would feel comfortable certifying that you were necessary for the care to trigger regular FMLA.
Got it. Got it. Okay.
That might, however, be an instance, actually, Rhoda, let's think about this too. The regular FMLA, just to put this out as well, regular ADA, excuse me, the regular ADA obviously requires us to make reasonable accommodation for the employee's own disabilities,
Right.
but the ADA does not require accommodation for other people's disabilities. So
Sure.
it would not require accommodation for your mom or dad's disabilities, for example. And so you're thinking through that as well, that, I'm thinking about, does the FFCRA apply? Does the FMLA apply? What would the ADA have me do? If you get through that whole list and there's nothing that's legally obligating you to do anything, we still have the overriding encouragement from our state and federal governments to allow people to work remotely as often as possible. And so that's another thing that I'm thinking about is, even if I'm not triggered by a certain law, if I'm thinking about the state orders in place, encouraging us to have people work remotely, what can I do there?
Sure. Sure. That's a good point for sure. We've had some questions about, this whole thing about undue hardship and so forth. What might qualify as undue hardship to a business for which they could deny a COVID-related accommodation request?
Yeah, that's a tricky question to answer. And yeah, it's a tricky question only because it's very fact specific. But one thing that might come to mind is there are some people with medical conditions that make it difficult or impossible for them to wear a mask. And You might have a workplace, for example, where someone's in very close proximity to other people on a regular basis, and it might be an undue hardship or not reasonable for you to excuse that person from wearing a mask. In some businesses, it might be perfectly reasonable because you can maintain social distancing. Maybe you could have the person wear an alternative face covering. For example, face shields are less good than masks, but if you have social distancing in a face shield, maybe that's something you could do. But if you're in a place where people are very close to each other on a regular basis and you cannot maintain social distancing, and a person is not able to wear a mask, that might be a time where you deny a request to not wear a mask. But you might then think about other things. You know, do you provide the person with a leave of absence? Can you provide them on a temporary basis with a different job? Have them work in a different location. So it's very fact specific, but that's something that's come to mind because I have had some employers wrestle with that issue of an employee that cannot, for medical reasons, cannot wear a mask, or cannot wear one for a sustained period. So that's one example that comes up. Another example would be, let's suppose you have one employee who is mission critical, like who does a very key thing in your business, and he or she is the only one that knows how to do it. Perhaps it would be a hardship to have that person out. But of course, then there you rub up against, like, if they're not going to come in, what are you going to do? You know,
Yeah.
you can't require them. So another example of undue hardship might be something that's very, very costly. You know, if someone says, I don't know, I could come to work, but only if you build an addition to the building that only I can go into. Or I could come into work, but only if you upgrade the entire building's HVAC system, which might be more costly than a small business could bear.
Right.
Something like that. If something is very costly, very significant expense.
Interesting. Okay, so now we've had an interesting question come in. We have just a few minutes left, so we may only be able to get one or two more questions. Is it now the case that in a healthcare setting, some non-clinical employees can be non-exempt and the clinical staff be exempt? Non-clinical,
I'm wondering if the person's asking about the exempt or new FFCRA regulations.
I'm not sure, because if you're talking FLSA,
Yeah.
you know, exempt, nothing changes there in terms of the type of position it is.
I think I just saw the questioner say yes, that her question is focused on the FFCRA.
Okay.
So the answer is yes, that you might have a difference between clinical and non-clinical staff. And the reason for that is that when the FFCRA regulations first came out, they said that anybody working for a healthcare provider, anybody at all, so, you know, the receptionist, the janitor, the, you know, you name it, anybody working for a healthcare provider could be exempted from the FFCRA and not provided with FFCRA leave.
Got it.
There was litigation around that. There was a lawsuit around that, and a court in New York found that that was overbroad. It was too much. The Department of Labor had overstepped. And so the Department of Labor issued new regulations that went into effect on September 16 that said that now the only people who can be exempted under the healthcare provider exemption to the FFCRA are those that are capable of providing healthcare services. So if you had someone who worked in billing, for example,
Right.
well, the billing person is not medically trained, is not capable of providing healthcare services. So that billing person would remain FFCRA eligible if the employer has under 500 employees, whereas, you know, a doctor, a nurse, other employees who are able to provide healthcare services could be exempt from and not provided with FFCRA leave. Does that make sense? The whole point about that, and I know we're short on time, but the whole point about the healthcare thing is the Department of Labor originally put that exemption in because they wanted all hands on deck from a healthcare provider perspective to be able to help people with a health crisis.
Yes.
But they want really the hands on deck that are able to help with a healthcare crisis and provide care, not those that provide other important but not care related services.
Yes, that makes sense. That makes total sense. And we're close to being out of time here, Jen. I want to know if there's anything else that you feel you want to speak to that hasn't been asked or any last parting thoughts that you want to leave the listeners with that they should be bearing in mind?
I guess what I would say is a couple of things. Number one, thank you. This has been a lot of fun. I like the conversation format. Secondly, know that you're not alone. This is confusing, and you've got to have a nice concrete checklist in your mind, and it's hard to get it in your mind and keep it there. Feel free to reach out to help. Reach out to KMA, reach out to the lawyer with whom you work, talk with each other. Don't be afraid to ask for help. And do what you can to be flexible in the short term. I really think that flexibility is going to go a long way. It's not easy. It can be really tricky,
Right.
but there is a greater expectation around flexibility than there has been historically.
Yes, I have been telling people that flexibility is the new F word to employers because they don't like to have to be flexible.
I like that.
So, but it serves us well to be flexible. And, we KMA would love to be able to schedule, more of these types of conversations with you, Jen, and so forth. And we thank everyone for being here today. We've been recording this, and we're going to put it on our website at some point, as well as we will follow up, like Jen said earlier, with some URL links to some sites for additional forms and Q&As and that kind of thing. So thanks very much for being with us today. And Jennifer, thank you so much for your time. This has been super informative. I can't even believe you got all this stuff going on in your head, but you kept it straight really well.
Well, thank you. It was a lot of fun. It was a real pleasure. Thank you.
Thank you. Thanks, everyone. Have a good rest of your week.
Thank you.
Bye.
Bye-bye.